four that I mentioned, designs, patents, trademarks, copyright, there are South African acts which protect those types of intellectual property. So today we're focusing mostly on trademarks and copyright. And I'm first going to speak on trademarks. Then secondly, as I said, copyright. And then thirdly, we'll deal with some highlights of the commercialization of basically and mostly trademarks and copyright. Okay, next slide.
Okay, B. What's going on?
Okay, well, I'll carry on so long.
Sorry,
so trademarks.
For some other, oh, is it gone? Okay, sorry about that.
No problem. So from a trademark perspective, you can acquire rights in two different ways. Firstly, by registering your trademarks in terms of the Trademarks Act. And secondly, by using your trademark, you acquire common law rights. So the use, promotion, and exposure of your trademark is acquired over time. The rights are acquired over time, but they are only acquired, for example, if you've got a business in Durban, you would only acquire common law rights in the Durban area, where your business has clients, customers, etc. Whereas in terms of the Trademarks Act, if you register your trademark, you blanket the whole of South Africa, and you then have an enforceable registration. So if anyone uses a trademark which is in any way confusingly similar, phonetically, visually, or conceptually, in relation to the same or similar products, you would then be able to enforce your rights. Okay, next slide. So what is a trademark? It is a mark, and the term is very broad, and we'll get to some examples in a moment, but essentially it is a sign that is capable of distinguishing your products or your services from those of others. Okay, next slide. All right, here are examples of marks. You'll see the list down the left-hand side: a device, which is like a logo, a name, a signature, a word, a letter or letters, a numeral or numerals, shape and configuration. Even the shape and configuration of your products can be registered as trademarks. Pattern, ornamentation, color or colors or combination of colors, and containers. So a few of the examples here are some devices or logos, like the Google logo, Universal logo, Coca-Cola ribbon font, as they call it. Okay, next slide. Here are some words, and normally when you protect a trademark, you should first register the core word trademark. It's the broadest protection you can get. It's the word in ordinary block letters. It's without limitation as to a font, a design, colors, etc., etc. It's the broadest protection. So if you have a new brand, you'd normally register just the core words in ordinary block letters, and that's the broadest rights. The examples here: Adidas, Mercedes-Benz, Coca-Cola, Kodak, etc. Okay, next slide. Here are some examples of letters or numerals. Now, remember, as I said just now, a trademark must be distinctive. So the view of the registry is that a single letter is not distinctive at all. No one can monopolize it. So you'll see these have all been filed or dealt with or used in a logo form. So that enhances the distinctiveness. So the Facebook F logo will not, they won't be able to monopolize the letter F, nor, for example, the S in Superman. And very often, the registrar will only let you register 2 or more letters in combination, subject to, for example, a disclaimer in that you're not entitled to prevent another person from using the letter F or the letter S or the numeral 3. Next slide. So just before we go on, I just wanted to explain that a little bit more. So you've got, for example, radio stations where it's, for example, 702 or 94.7 or something. That's 3 numerals or 3 letters like BP. And there the registrar would often say, okay, well, that's more than one. And normally he likes to only accept marks that have 3 numerals or 3 letters, which he then will accept as sufficient that you've used it for a couple of years, it has become distinctive through use, and then you can also get it registered. So there are 2 bases: inherently registered, which it means it's inherently distinctive, or it's capable of distinguishing and it has become distinctive through use. All right, and then here are some examples of names. Now, names are often, like here, the name of famous people, famous sportsmen, designers, etc., etc. Peter Stuyvesant, obviously, that was cigarettes. Daniel Hector, Pierre Cardin, clothing, etc. So the names are often of famous people who have then commercialized their brands. New slide. Here are some examples of devices or logos. There's the BMW. There's 3 letters there, and also they call it, I think, their propeller device. There's also Mercedes-Benz, which is a combination between the words and their logo. Then there's Apple, the Apple. Then there's MWeb, which is a combination between the letters and the M logo. And obviously there's Mickey Mouse. New slide. Yeah, you'll remember the mark includes patterns and ornamentation. The Nike swoosh is well known. If you just see it, you know it's well known. Then the Adidas 3 stripes, also well known. Can't remember the pattern. The ladies should know. I think it's a famous Gucci or something pattern. I can't remember myself. New slide, please. Then obviously you can register colors and color combinations. So Cadbury's, for example, have a lot of products in purple. They've tried to protect the color purple for their trademarks. Then an industry where you can often see the colors, and the main players in the sort of fuel industry, like BP, has got its colors. Engine, it's got its colors. Shell, Sasol, and you'll often recognize those service stations because of the colors or the color combinations. And those, obviously, if they're distinctive to you, if they're important and part of your brand, you can register the color logos or the colors. So BP, for example, would register BP as letters. They probably had to show the registrar this has become distinctive as a result of use. Then they would file the logo as you see there with the little star or flower device and the combination probably as well. That's what they have as part of their corporate identity to distinguish themselves in the market. Then on the left-hand side, you've got Lego. Those are unique, distinctive shapes. And as I said, you can protect also the shape and configuration of your products by way of trademark protection. And you'll also remember that I mentioned that some areas of intellectual property overlap, So yeah, you could, for example, have copyright protection, you could have design protection and trademark protection for three-dimensional products. So registered design is specifically to protect aesthetic designs, how something looks, and the shape and configuration of that. Then there's the face of the watch. Then there's some toothbrushes there. So those are shape and configurations that can be protected, like the BMW grille, the Jeep grille. Those can be protected also as trademarks. Next slide. Here are some containers. The one on the right, Coca-Cola. The Coca-Cola little bottle is probably the most famous container trademark on the planet, and has been protected and registered all over the world. And if you pick up a can of Coke or a bottle of Coke, you'll probably see the little TM or the little R in a circle. The TM means a trademark. You can always use that immediately. The little R in a circle, it's unlawful to use the R in a circle, which designates a registered trademark before the trademark has actually proceeded to registration. And if it's proceeded to registration in South Africa and not in Botswana, you can't use the R in a circle in Botswana. So you've got to watch your marking very carefully. But one can see there the different shapes of the containers, and one can register those as well as trademarks. New slide. All right, so I've spoken this couple of times about a trademark having to be distinctive. So a trademark, to get onto the register, it must be either, as I said, either inherently distinctive, or it is capable of distinguishing. Now, capable of distinguishing means often that something is not completely inherently distinctive. It's not highly distinctive, but as a result of the use or promotion exposure, it can become distinctive. So it's capable of distinguishing through use. Next slide. So here are some examples of trademarks that are very distinctive. So a trademark which has an invented word like Kodak or Reebok or Nike or Adidas. These are very distinctive trademarks. Now, obviously, because they invented words, they don't mean anything. So if a trademark is a unique word like this, you're going to have a broader scope of protection around the trademark. It's not like you registering something like Holiday Inn or City Lodge, which are not as distinctive, but become very distinctive through use. So you pick Holiday Inn, the trademark itself is not highly distinctive inherently, but those have become factually distinctive as a result of the use, promotion, and exposure over time. So when choosing a trademark, try and choose something more unique and distinctive. And if you want your brand to say what you do, then perhaps do that in a descriptor or a secondary brand, because you have a bigger scope of protection around something that's much more distinctive. To the extent that your trademark describes the products or services, you will have narrower protection, and people will be able to step closer to you in the sense of using words or phrases that are closer to your trademark. New slide. Here are now trademarks which are not invented words, but they are still distinctive. So the word apple for apples is not distinctive, but the word apple for computers is highly distinct. Diesel for clothing is distinctive, but diesel for diesel fuel is not distinct. Police sunglasses as well. So for sunglasses, police is distinctive. And similarly, the word castle for castles wouldn't be distinctive, but for a beer, it is very distinctive because it distinguishes those products from other beer products. Okay, next slide. All right, so now you're starting, let's say you've decided on a trademark 1, 2, or 3. You want to perhaps adopt it for use in your business. So the first step would be to check on the internet, Google search that there isn't something like that in relation to your products and services. Now, there are 45 classes of goods and services internationally, and you would protect your trademark in your classes of interest. For example, clothes would be class 25, a pen would be class 16 for stationery, your laptop or phone, class 9, where electronic products go. So your products and services get classified into one or more classes. So now you want to adopt a trademark, but it's prudent now to do a search. So if it's going to be a business name, then ideally you want the trademark, you want the company name, you want the domain name, correct? So you would then do searches, firstly on the trademarks register, because the trademark register or a trademark registration is the umbrella right for protecting a name, trademark, brand name, etc. On the basis of a trademark registration, you can force someone to change a company name, to change the domain name, service mark, product name, etc. So the first place to start is the trademarks register. You need to check there. There are lots of trademarks there. There are about 40,000 marks filed every year at the South African Trademarks Registry, and it's probably been going, I'm not sure exactly now, probably about 80, maybe even 100 years. So there are a lot of trademarks there, and they get registered for 10 years at a time, and you can then renew them indefinitely. So you need to do a trademark search to make sure your trademark is available for use and registration. Then you should also do a company search, because ideally you want the company and you want the domain names. New slide. So just go back a slide. Did we miss something? Okay, go to the next slide, please. So, as I said, the first step is doing the searches. And it's important to identify, do searches on, and then adopt something that is distinctive. As I said, the more distinctive it is, the greater rights you'll enjoy. And a very important reason for the searches is you don't want to start using a brand and 6 months later, as has happened to Charlotte, someone comes along and says, this is my trademark, please change yours to something else. So searches are very important. Next slide. All right, the process to register, ideally, you can do it yourself, but you're probably going to become unstuck at some point. I think 90% of people who register their trademarks, they file them and get them on the register, but they never proceed to registration because they don't have the skills. So ideally, you should approach a trademark attorney to assist you so that you can file it and then prosecute it all the way through to registration. The process can take 2 to 3 years, but your rights are then effective. Once you get the registration certificate, your rights always are backdated to the day you filed it. So you would file your application today in the correct classes with an appropriate specification. You would have your name, your physical address, and various details. Within about 2 days, you would get your filing particulars. That means your mark is on the register, and it then lies dormant, awaiting examination for about, now at the moment, 10 to 12 months. The registrar then examines it and sets out some conditions for acceptance. This is the first point now where people who are not trademark attorneys then become unstuck if they file the application themselves. Anyway, you need to then deal with the registrar's conditions for acceptance, place the application in order. In a few months' time, you receive the formal notice of acceptance. It must then be published in the Patent and Trademark Journal. It's like a government gazette for opposition purposes. If no third party interferes within the 3-month opposition period, then your mark is deemed to be registered. But then you can still wait for about 12 months before you get your certificate. And as I said, once you get your certificate, it's backdated to the day you file the application. New slide. All right, so why register? I touched on that briefly in the beginning. And so you do get common law rights by using the mark, but it is expensive to enforce, and the rights you acquire are quite limited. Whereas if you register, immediately blanket the country, it's much easier to say to someone else, here's my certificate, your mark is similar to mine, either visually, phonetically, or conceptually. It's you've adopted a trademark which is in relation to products which are similar to mine, therefore please stop. And it obviously makes litigation cheaper and quicker and easier. Also, if you've got a registration, it enhances the value of your brand because it protects the income stream. And the value of your brand is the net present value of the future income stream of your trademark. So the registration protects it, and obviously it will also facilitate the licensing or commercialization of that brand. And also, if you want to transfer ownership from you or your business to someone else, you include the details of the registration, and the registration is then transferred from you to someone else. So it makes it very easy, or far easier, to protect it, to commercialize it, to assign a value, and to deal with it in a commercial way. New slide. All right, so just go back a slide. Before we go on to copyright, I think we're quite a small group. If you've got any questions, I'm happy just to deal with them quickly before we go on to copyright. Any questions? Anybody? You're all experts now. That's good.
Wait. I have a question, please, but I can't get my finger. I had to put up. Charlotte, firstly, thank you for organizing this. And Eugene, thank you for enormous information. I quickly want to ask you, I have registered a TM for my business. My company's name is meant to be, and then in single, I write honey, and the B is a double E. It took a little while to get that registered because of the wording meant to be. But if you go back to government and you ask, obviously, I don't know, have they registered my name or the logo? Now you say we can register the name, the logo, the colors, and the containers. Is that one application, or is that 4 different?
No, they're all different. So, and to the extent you put, let's say you apply for, so number one, to answer your question, it's ideally it's separate registration. Sometimes if you've got let's say either the mark is not distinctive enough, or you just want to file a combination in the beginning, you might file, for example, the word Nike and the swoosh in one. But to the extent that there are more elements in a trademark registration, you've diluted your rights. So, for example, you now file a slightly different swoosh, but instead of being Nike, it's now Boertis with a similar swoosh. Now, the court has to decide, is there going to be confusion between Nike and Boertis? Because your Boertis has got a slightly different swoosh. Whereas if you registered only the swoosh, anyone who used a swoosh similar to that swoosh would probably be prevented from using their swoosh. So you dilute your rights by filing marks in combination. So yes, number one, you want to protect the word. Number two, you want to protect the logo. So now you've got the basic core word. Then next step, you want to protect your logo. Then you look at what else is important in your business. And you think of it as a pyramid with the word at the base. It's the broadest protection. It's the base of the protection. And you step up the pyramid by, for example, filing the logo, maybe a slogan, maybe a color mark or whatever. But as you go up the pyramid, the protection gets slightly narrower. It's not as broad as a word. So, for example, the logo would now protect the logo in that specific design. So it's very specific, but slightly narrower. Let's say you now want to protect your logo in colors. You file it in the color because your colors are very important to you, like BP. Their colors are important to them. They file their BP logo in color. But now their rights are slightly limited to the colors. Whereas if you file an application for a logo in black and white, it's deemed to be registered for all colors, and you generally have protection in relation to all colors. But you BP now, so you step up, one level up, and you file the application in your colors, which are sort of yellow and green, and you then are able to prevent anyone else from using those specific colors or color combinations in relation to products or services which are similar to yours. So you need to, if you want to get my email address, I'll quickly get it from Charlotte. I'll quickly check for you what's on the register and let you know within a day or two what is there, if you wish. Does that answer your question?
Yes, it does. Can I just ask, please, while you're on this, and sorry, I have another question.
Yeah.
I'm in the honey industry, and the honey in South Africa have a low entrance in the world. So Manuka Honey is marketing, they have trademark their name and everything. Can I, for instance, if we get the same registration or all the same ticks as what as what Manuka have, and we want to trademark Fynbos. Now it's a very tricky one because Fynbos belong to South Africa, the honey. Can I, if I do the spelling different, so instead of BOS, can I say BOCH for Fynbos and trademark that?
Yeah, you could possibly. But remember, you wouldn't be able to stop someone from using the ordinary Fynbos word. So let's say you start a bakery and it's Charlotte's brown bread, okay? And you file it in the correct classes, including class 30 where brown bread goes. So now you can misspell brown bread. You could spell it B-R, I don't know, something else. I can't think of a spelling now, and bread, B-R-E-D. Okay. So yes, you would get protection in your specific spelling, but you can't stop someone else from using the ordinary spelling brown bread. Okay.
Okay.
So you do see sometimes people misspelling something, and they might get a registration, but the registration doesn't go very far. You know, it's like registering apple for apples, now apple fruit, and you registered APPL, let's say. You would get protection for your version or spelling, but you can't stop someone else from using the word apple for apples. All right. So it's a
thin line.
It's a thin line, and you're getting very narrow protection. And ideally, sometimes that's part of your marketing, it's part of your plan, etc. I understand that. But if you want a bigger scope of protection, you pick something like Engen or Kodak or Marmite or Bovril, and no one can come close to you. Can you see? There's a much broader scope of protection there. All right.
Yeah. Thank you so much. Thanks, Eugene. Thank you for answering.
Pleasure. Any other questions on trademarks before we go ahead to copyright? Okay, should I fire away? So copyright, as I said, is also a type of intellectual property, and it's a statutory type of intellectual property. And in South Africa, the slide says no registration. That's not 100% correct. Generally, copyright works in South Africa, and every business has copyright come into existence automatically. And there is only a registration facility in South Africa for films. So if you're an international film producer, or you make a little film in South Africa or internationally, you want to protect it in South Africa, there is a facility to register copyright in a film. New slide. We want to go forward. Okay, these are now the types of work covered by copyright. So artistic works, which would be even technical drawings, paintings, photographs, portraits, many different types of designs. Next thing is literary works. These are, think of a book, think of a report, think of a document, publications, etc. Musical work, you'll know that. Films, you'll know that. Sound recordings, you'll know these. Broadcasts, program carrying signals, published editions. It's similar to a literary work, but may also be a combination of a literary and an artistic work. And then obviously software, computer programs. So those are the different types of copyright in South Africa. New slide. So as I started saying in the beginning, copyright comes into existence automatically. So generally, if you spend time, effort, labor, skill to create something with a new original character, you will automatically enjoy copyright protection. And that copyright protection will extend to, I think it's about 280 countries at the moment, whichever countries have signed the International Berne Convention. So you write a page, let's say you write a page, a little short story or something, and you do it in your own time, you're not employed by anyone else, you would be the owner, and you would have the right to stop someone else from copying, adapting, plagiarizing your new literary work. So it must be original, it must be reduced to material form, it's not an idea. Intellectual property protection doesn't extend to ideas, it must be in some sort of material form. Next slide. So, with regard to the ownership of copyright, now this is a big pitfall. Remember, it comes into existence automatically. And the general rule is the author is the owner. So a pitfall, for example, in South Africa, you go to an ad agency or you go somewhere to write a new ad for your advertisement or do a new corporate identity or a new logo for your business. And even once you've paid them, yes, you have a right to use the logo or that ad, but you are not the owner. So the general rule in copyright in South Africa is the author is the owner. There are only 5 exceptions. If you commission someone to take a photograph for you, to do a painting for you, to do a portrait for you, to do a sound recording for you, or do a film, and you pay them money, even though that they're the author, you will become the owner by law. My suggestion, though, is that whenever you deal with copyright, you deal with it in writing. You commission somebody, you ask them to do your logo, you ask them to do your ad for you or your website or whatever, and you commission them in writing, and there must be a clause in that agreement that you acquire ownership of that work that's been created for you. So if you don't, you only have a right of use. So it's a big pitfall in South Africa. So if you want to buy land, you want to buy a house, you want to buy a car, it needs to be a contract in writing, and deal with copyright in the same way. So I can just tell you a quick story. A guy went to an architect, and our technical drawings are an artistic work, and the architect, he paid a fortune to the architect and designed him a beautiful house. He built the house, and years later he went to an estate, and he found that there were a couple of houses similar to his. He was very upset and went back to the architect, and the architect said, yes, you paid me a fortune, I designed the house for you, and you had a right of use. But I still own the drawings, and therefore I've put up some houses using those drawings. So that's the same situation. If you outsource, the general rule with copyright, you outsource it, red flag, you probably don't acquire the ownership. So if you commission someone to do a logo for you, to help you with the website, do a software program, whatever, my suggestion is either you commission them up front with a written agreement, or somewhere along the line, you ask them to sign a copyright assignment agreement. Normally, these people, once you've paid, they're quite happy to transfer the ownership for you. People, however, forget, and they end up not having ownership of their, let's say, their corporate identity, but they only have a right of use. All right, next. So duration of copyright can be quite complicated, but generally speaking, I'm just going to leave you with this. It's usually at least 50 years. So 50 years from the date it's published. Sometimes it's 50 years from the date the author dies, but generally at least 50 years. All right, next slide. Sorry, and on that point, some countries in the world have extended it now to 70 years, like the US. They've extended copyright to 70 years. So artistic and literary works, here are some examples of, for example, packaging, combinations between literary and artistic works. New slide. Here are some old drawings of an old Nokia. Some of you might remember those phones. There would have been technical drawings on those phones. There was copyright in those technical drawings. And in the manual for the drawing, there would be, it would be a combination between a literary and artistic work. New slide. Here again, the copyright here would be in various things, in a software program or a game. There would be artistic works, there would be literary works, there would be software, there could even be films, film track, or a cinematographic film. In terms of copyright, is just a sequence of images that are moving, and therefore a computer program or a computer game would also enjoy copyright as a film, as a music work, etc. Next slide. Here again, packaging, most packaging enjoys, somebody owns the copyright in the packaging. I would guess that a large percentage, maybe 60–70% of packaging out there is not owned by the proprietor, because they've outsourced it and they've never taken ownership. So as I mentioned, that's a key pitfall. So here, if you pick up your phone for a moment, it's full of IP. There would be copyright in the app. There would be license or T's and C's in the app. There would be patents in the design and functionality of the phone. There would be registered designs in the way the phone looks. There would obviously be brands. The brand could be the word, could be the logo, could be the whole phone itself, could be even a layout of the phone. And there would be a lot of copyright as well. So we are, as the slide says, surrounded by IP. Right, any questions on, go back a slide, any questions on copyright itself?
Quick one,
Right,
Eugene.
yes, sure.
Are you able to copyright a hashtag?
Okay, so now the hashtag, okay, so, all right, the hashtag exists. All right, so you can't copyright something for you because you haven't designed it. It's not a new original work by you. So the hashtag itself is in the common domain. It's like the little R in a circle symbol. The hashtag is also a common, let's call it a common sign or icon. But if you had your own version of the hashtag, then let's say you design your own version. So then you could get copyright protection in your own version, subject to the fact that someone might own the original hashtag. If someone did, then they would have the rights and you might then be infringing theirs. But if it falls in the common domain, then you wouldn't be able to stop someone else from using a hashtag to the extent it falls in the common domain. So only to the extent that you have created some sort of additional unique design feature, you may then enjoy some protection in your unique version of the hashtag. So, I'm thinking of tree devices, for example. There are a lot of tree devices out there, and I think FNB's got one, and they can't stop someone else from having a tree logo or tree device. They will get protection in their own specific tree logo, but their rights would be limited to a tree logo that is very similar to theirs and wouldn't be able to prevent someone else from having a tree logo that looks like a normal tree, which is very different, let's say, to their specific tree. Does that help?
Yeah, Eugene, what I meant, sorry for that. What I was meaning was the hashtags that you'd normally use, after you've done a post or on Twitter or something, use a hashtag and then it has got a description like impact a country or something like that that goes back to your website. So with the copyrights of the hashtag in that way, that's what I meant.
Okay, so now, like a domain name. So let's say the domain name says avis.com or avis.co.za or Avis Fleet Rental, whatever. So, or a hashtag Avis or a hashtag Moore Roberts or a hashtag whatever you say. So to the extent it is distinctive, you can register it as a trademark, and then you could prevent other people from using that. But a simple hashtag something, you're not going to easily get any protection. So like a domain name, like a company name, they get onto those registers, and to the extent someone comes and tries to register something identical or very, very similar, the registrar may not allow you. They'll say, we've already got that, yeah. So those registers don't really provide protection. The companies register for the purpose of registering companies, domain name registration for registering domain names, and a hashtag, you indicating it as a tag to your website or some sort of initiative or project or something. If you want to protect those, you need to protect it as a trademark. You can then prevent anyone else from using it in whatever form they use it, because you've got the umbrella right, the trademark registration. So to the extent it's ordinary English, like hashtag, let's say Apple, obviously for computers, that will be distinctive. Hashtag Apple for apples is not going to be distinctive. Does that help?
Oh, that was perfect. So I need to just trademark first and then use that as a hashtag, and it then comes back to me.
Well, ideally, you should do a search first on Google, see no one has got it for your products or services. Then, yes. Then if it's available, and sometimes
I've done this search and there's nothing available. It's unusual and it's different. It's unique. So I've looked at all the areas from company to registrations to websites and the hashtags. So I've searched everything.
Okay, great.
It's available.
Well, then if you're confident, then you could perhaps just file it straight away as a trademark. And then you would get you would ultimately get good registered trademark protection, and you could stop someone else or anyone else using the hashtag for the same or similar products or services.
Oh, that is brilliant. Thank you.
Eugene,
there's some questions coming here on chat box. Oh, sorry, Lorraine. I see you posed a question on chat box. But
yeah.
I can't see the chat.
If ChatGPT,
I'll read it out to you, but Lorraine is online.
Okay. Cool.
It's my question. If AI creates an image for me, is it my image?
Okay. So we can talk all day on that. So I think you would need to. There's a lot of problems with that because there's copyright infringement. People, some of the leading music and some of the leading publishers in the world are now claiming copyright infringement because some copyright protection extends to something that's identical and to something that's obviously similar or an adaptation of the original work. Now, let's say if you give an instruction to ChatGPT, you give them two logos, create a combination of the logo. Now you might be infringing both logos. So it depends on your instructions and from where ChatGPT got that. It's like asking it to write music and please take note of these 10 songs. Then it writes a combination song. It might be infringing all 10 of those songs. Does that answer your question?
Yeah, enough. Yeah, but if I've created something that looks like a photograph, yeah, it is really difficult. I think with text, though, if you've had, I think you just need to admit that you were helped by AI or AI wrote the article for you. Thanks, Eugene.
Eugene, there's another question here.
Let me just finish that one point. So on ChatGPT, so let's say you wrote an article and you asked it, you just put the article in and you said, just correct the grammar for me. Now, you've written the article, you've not copied from someone else, you've created a work with a new original character, you will own copyright in that, unless you're employed to do that, in which event your employer would probably be the owner. So now you own copyright in the article. You've only used ChatGPT to refine the language, to update the grammar for, let's say, for business purposes. So you'd probably own it. So in anything, the short answer out of ChatGPT, you would need to understand what it used and also what instructions you gave it, and yeah, what went into it Let's say I ask a junior in my team to write an article on a new exciting project, and I give him 2 articles. And he refers to those articles and he says, please write me a combination article. Now, there might be substantial parts, and infringing copyright is not a quantitative test, it's a qualitative test. I'll give you an example of that. A motivational speaker copied 1 paragraph out of a 300-400 page book, and the court found it was a substantial part of the book, and therefore the books had to come off the shelf. So it's not, some people think if you copy 5%, 10% or whatever, it's fine. If it's a qualitative assessment, if you copy a substantial part, it's an important part, and it doesn't have to be, it could be 5% of the work, but it would still then be infringement. So you'd need a little more information about where ChatGPT got its information, what was put in, etc., etc. Okay. On the basis that's okay. Next question.
Right. So as authors, we are advised to get ISBN code for our books. Is this enough for registration?
For registration of what?
Obviously, the book. That comes from Ntabi
So
Singh.
the book.
Ntabi Singh, do you want to be a little bit more clear on that so that Eugene can answer?
Yeah. Yeah.
Is Ntabi Singh still with us? Ntabi Singh, you there? Okay, let's move on. We are running out of time.
Sorry. Okay, so I'll be quick now. Next slide. All right, so now we're going to chat a little bit about firstly about ownership, and then a bit about commercialization. So usually the IP is amongst the most valuable asset in any organization. In a group, obviously that is often the case, and you would then want to have your IP housed in a holding company or an IP holding company. So the holding company, there is often, there are less trading risks there, and even more so in an IP holding company. It will then license or grant the use of that brand, that copyright, whatever, to the divisions within that company. So often initially you would have the IP registered or owned by the primary entity, but over time, as you expand, as you commercialize, one must consider then transferring ownership into a holding company or an IP holding company. Okay, next slide. All right, so licensing structure. Now, licensing intellectual property is similar to sort of having an owner and a tenant. The owner owns the intellectual property, and the tenant has a right of use of the intellectual property. So in a licensing structure, you've got the IP holder or proprietor, and they would allow the use of, let's call it that, brand by a licensee. On the left-hand side, the examples of direct licenses to the licensee or user. The next alternative is, let's say you want to, the IP holders in South Africa, and he wants to expand into Botswana. He would, for example, appoint a master licensee in Botswana, and the master licensee could then exploit or commercialize that IP in Botswana. Then in a bigger structure, the IP holder, that's on the right-hand side, appoints a global master licensee or franchisee to commercialize internationally. It could then grant sub-masters regionally, let's say in the Middle East, and then that entity would then grant licenses in that region. New slide. All right, so we've got trademark licenses and franchises. I think just to be quick, I'm going to just focus on franchising, because here you are licensing a couple of types of intellectual property. You often, in almost every franchise I've dealt with, there's usually a brand, there's usually copyright, and there's some sort of know-how, trade secrets, confidential information, expertise, etc. Next slide. So examples of franchise type arrangements would be vehicle dealerships, although they often don't like calling themselves franchises. Fast food restaurants, that's probably the most well-known. Car rentals, certain retail chains, like some Pick and Pays. Many Woolies used to be franchises. Most fuel stations are franchises. In South Africa, about 15% plus of GDP is actually generated by franchise type businesses, where you've taken a successful business concept and you've refined it, and then you license it out. You've commercialized it and granted rights for franchisees to use that business system at new locations. New slide.
Sorry, I'm trying. There we go.
All right, so there, very quickly, you can arrange, if you're licensing or franchising within your franchise system, to be paid various types of, or have various types of income streams. There could initially be the setup costs, there could be rights to acquire the license, there could be a premium because you're a well-known brand. So those are initial amounts. Then there could be royalties, which could be a fixed amount or a percentage of turnover. The average royalty in South Africa amongst franchise systems is about 5 or 5.5. I think it's 5.5% of turnover. Next slide. All right, so other amounts that could be paid by the user or licensee or franchisee. Very often, if there's a brand license or a franchise, the user contributes to the marketing spend. Then there could be other payments as well. If the franchisor does some accounting, does some administration, does some management, procurement, rebates, renewals, resale fees. There could be several income streams within a license or franchise system. Next slide. I'm not going to dwell here too long, other than to say, be very, very, very careful granting exclusive rights ever, or sole rights. It's tantamount to handing over that, for example, that territory to someone for a period of time, usually 5 years, 10 years, or whatever. It's tantamount to, let's call it a sale for that period. So if you're going to grant exclusive or sole rights, then there should be minimum performance standards. And then quickly to add, there are various licensing options. You could license this intellectual property from there, that intellectual property from there, or create a bundle and then license it out to franchisees. Just being smart, you can commercialize and make money from IP, not always just your own. All right, new slide. Okay, so this and the next one or two slides, the intention here is every business has some valuable IP. It might have a brand, might have copyright, might have know-how, etc. Know-how, systems, processes, expertise, confidential information, trade secrets. Next slide. So what you want to do on an ongoing basis in your business is understand what is valuable and what can be commercialized. The examples I've got there, the first example is the Avis Wizard system. They, at a period in the world, they had the best car rental operating system. So they even rented their Wizard system, their operating system, to some of their competitors. So they made money from their fantastic operating system by licensing the system out to people, to competitors who were obviously using a different brand. Nando's as well. Nando's, yes, you know it as a franchise, and yes, you know it as their sauces, their products. So they make a lot of money by having their sauces and condiments through different retail channels like Pick and Pay, Woolies, Spar, etc. So there they identified an opportunity. In addition to licensing business systems, they commercialized their products separately. Again, a car wash business, very simple, straightforward business. You package it smartly, even very basic concepts, and you can have a successful business. Other examples are mobile food or business units can also be commercialized. It's just coming up with a smart product offering. Doesn't have to be too sophisticated. You put it together, refine it, and then license or commercialize it. All right, new slide. Very briefly, international expansion. You want to make sure you've got IP protection. You want to make sure your contract is locally compliant and enforceable. You want to make sure that you've got exchange control approval so that you can get your money from your licensees. And there must also be tax and transfer pricing considerations. New slide. All right, in conclusion, to wrap it all up. So IP in most businesses are the most valuable assets. All right, so what should you do to manage these things? These assets should be managed at the top level, at strategic level in any business. Number one, always, are they properly protected? Number two, are they effectively and efficiently utilized? Number three, are you looking for opportunities in the market? Continually look for opportunities, because there may be opportunities to commercialize parts of your business or systems or copyright or trade secrets to third parties. Maybe even if you've got a fantastic chili sauce, you might want to license the recipe out to someone else, but under their own brand. You've then licensed not your brand, but the know-how, the recipe, the methodology, the process, etc. So in short, protect your IP and continually look for opportunities to commercialize it, and do so where you can, because there's certainly opportunities, particularly in Africa, I've found, for good products, good services. Thank you. Are there any questions?
Please, can I
Hello,
ask another
everyone.
question?
Please don't be shy to ask a question. I think it's important.
Charlotte, can I ask another question for Eugene?
Certainly.
Eugene, thank you. Eugene, you spoke about franchises. So can I just ask you, if everything is in place in South Africa for my company, I have the TM and everything here on the logo, the words, the color, the container and everything, but I export. Do you have to register all this in every country that you're going to? Like, for instance, Dubai, Indonesia, USA?
Absolutely. Absolutely. So it's an intellectual property right. If you want to register your trademark in South Africa, you register it at the South African Trademarks Office, CIPC. Okay. If you want to register now we've got a client now is expanding their franchise internationally, as many of them do. You need to now go and register your trademarks at the registry in that country. So you need to register your trademarks there. You need to make sure that your agreement is compliant and enforceable in that country. You also, and remember, you got copyright, but copyright will probably extend. So if you're a franchise, for example, you'll have an operations manual, you might have a website, you might have other documents, you might have a corporate identity. That protection of the copyright would probably extend to those countries. So you would have a lot of protection already for your copyright. You would just need to register your brand.
Okay, thank you. It's a very expensive way to do it, but obviously.
Well, yeah, but now you do it smartly and you do it as you go. You don't need to register in the whole world. You're now expanding into a new country. You ask your licensee or your master franchisee in that country to pay a deposit. Ideally, you've actually registered before that, but that's at the latest. Before you enter into any contract with them, you've filed your trademarks there at the registry in that country. Then you license the rights to them in that country.
Thank you so much.
Any other questions, ladies? This is your opportunity.
Yeah, Eugene, what does it cost to trademark a word or a sentence?
Okay, so in South Africa, I'm at Adams&Adams. We're not the cheapest in the market, but you'd to file one application, one class, it'd be about 5,000 Rand. And then in about 10 months' time to 12 months' time, you'll probably pay another 3,000 Rand. Okay, so that's for one application and one class. If you've got, let's say you're Nike and you need to protect in class 25 for clothing, you also want to protect in class 28 for sports gear, and you also want to protect this brand as a trading name, which is class 35, which you don't want a third party to use the same Nike brand in relation to a business name. So now you've got three classes. It's probably going to be about 15,000 Rand, but we usually give discounts if there are a number of classes for the same brand. And then in about 10 to 12 months again, you would then, if things all go smoothly, probably pay about another 4,000 or 5,000 Rand to complete the registration process. So yes, it can be expensive, but you know, there are many, from our firm, there are many additional services that we don't charge for. We search, for example, every month on the registers to see if anyone's going to be copying you, registering a company, domain names, etc. as a free service. We also include reviews. So yeah, look, the short answer here is probably going to be your most valuable asset. And it's very short-sighted, to be quite honest, to not protect your most valuable asset.
Thank you, Eugene.
Well, ladies,
we get your details from Charlotte.
I'll drop it into the chat box now.
Also on my website,
Here's the email address. I'm just sending it to everybody quickly. But thank you very much, Eugene. This is unbelievably necessary. And I want to just say from my experience with Eugene, and it so happens, and I didn't even know this, Eugene, apparently Kim and Jeremy Everett have been working with you for some time now as well from Neurocoach and Business Institute. I think it's just so important, ladies. Doesn't matter how small your business is, or doesn't matter how small you think you are in business or in the world of business. I think if you've worked so hard on building something and somebody else comes and whips it out from under you, it can be soul destroying because there's an emotional attachment to your business, to the name, you know, to the concept. and to the point to your copywriting. So I think, Eugene, thank you very much. I know this time is precious for you as well, and that you've actually given us this time today. We really appreciate it. But I have dropped the email, but if anybody needs to get in contact with her, please, you can contact me with the greatest of pleasure. And I will share it. And then I'll also share this recording again, because I'm sure there might be some golden nuggets here that you may have missed, or may just want a repeat of it. But thank you, Eugene. We appreciate it. We went slightly over time, but I do think it was well worth it. I do think that this is very, very necessary. And thank you for everybody with the responses coming, Eugene. This has been very informative. Somebody, in fact, it was Arthur, that said, at last we've got somebody who can actually explain this very, very difficult conversation. I am, as I say, going through this, the motions with Eugene at the moment. I can give you feedback on how I'm experiencing it. But at the end of the day, you know, there is a cost to it, but the cost in the long term could be far greater for you if you don't invest that in your business today. Anything else you'd like to say as we end, Eugene?
From my side, yes, it's been a pleasure. Thank you very much for the opportunity today. It's been nice talking to you. Thanks for the questions. And yes, it is a complicated area and it can sometimes get expensive, but in the bigger scheme of things, these are the most valuable assets. And you spent a lot of time building your brand, building your business every single day. Spend a little bit of money to get good protection, and that will serve you in the long term. It will protect you. And we have a very, very busy anti-counterfeiting team, a very busy trademark litigation team. Because as your brand grows, it's a sort of like a backhand compliment, copiers come in. So the more time and effort you put into building your brand, the greater the likelihood that someone's going to want to steal part of your income stream, copy you, have something similar, etc. So get some protection up front, ideally with a distinctive trademark. You've got a bigger scope of protection. Look after your brand. And yeah, thank you from my side again. It's been a pleasure.
Thank you very much. Thank you to everyone, and enjoy the rest of your afternoon. And as I say, be in touch with us if you would like to get in contact with Eugene. Bye, everyone.
Thank you. Thank you.
Thank you. Thanks, Eugene. Thanks, Charlotte. Bye.